Good evening, everyone, and welcome to our first webinar at the T.M.C. Asser Institute. My name is Leon Castellanos-Jankiewicz, and I am researcher in international law at the Institute. And on behalf of the Institute, I hope that you're all safe and healthy this evening. I am joined today for this webinar by my colleagues from the Institute, Dr. Rumiana van Ark and Rebecca Mignon-Madavi, whom I will introduce in a short moment. Today's live briefing will explore the topic of counterterrorism and national security, forever and anywhere war. And essentially, we will explore the extension of counterterror strategies in time and space in each of these presentations, which will be followed by a Q&A session together with you. Before we get started, I'd like to go over a few housekeeping items for the session. At any time during this webinar, you will have the opportunity to submit questions to today's presenters, and they will be able to answer them at the end of the presentations. I will be moderating the Q&A session, so to ask a question, just type it in the chat function at the bottom of the control panel. We will share a link to the recording of today's presentations at a later time on the website of the Asser Institute. The webinar will proceed as follows. First, Rumiana van Ark will speak for 15 minutes, and she will be followed by Rebecca for another 15 minutes. And we will close with our Q&A session, which will last 25 minutes. Before we say goodbye to you, we would like you to fill out a very short poll that will pop up on your screen right at the end of the Q&A session. And we would very much appreciate your feedback as to what you think about this event so that we can use your input to organize future activities such as this one. My colleague Rumiana van Ark will kick off this seminar. Rumiana is postdoctoral researcher at the Asser Institute and a research fellow and coordinator in the International Center for Counterterrorism here in The Hague. Her research explores the impact of counterterrorism measures on individuals, including people suspected of terrorist behavior, and the longer-term implications of the rule of law. After Rumiana, Rebecca will take the floor. Just to briefly introduce her as well, Rebecca is researcher in international law and counterterrorism at the Asser Institute, which she joined only last year, and a research fellow at the ICCT. Her work reflects on counterterrorism and more precisely on our evolving legal and policy capacity to deal with security threats, where new forms of non-state transnational strategy and technology are in play. So the focus of both presentations will be the anticipation of threats, which has resulted, according to our panelists today, in a blurring of lines of temporality and the border between the criminal and the pre-criminal space. For now, let me turn it over to Rumiana van Ark. Rumiana, you have the floor for 15 minutes. Welcome.
Thank you, Leon, for your kind introduction, and thank you everyone for joining us this evening. I hope you and your families are keeping well in these anxious and strange times. What I would like to do is to start a little bit by addressing the themes of legality, legal gray zones, and legal uncertainties, as these are themes that will run both through mine and Rebecca's presentations. What I will then proceed to do is have a quick and brief overview at the US war on terror with emphasis on the Bush administration years. Rebecca will take over the baton and have a quick look at the Obama administration years. And the second case study that I would like to look at, again, briefly, would be the United Kingdom in comparison to the US approach in terms of its counterterrorism operations extraterritorially, and in particular, the UK approach, which can be summarized as trying to close all legislative gaps, both for now and for the future. So if I start with the legality and legal gray zones first. A legal gray zone has been very masterfully described by David Disenhouse as a legal space within which there's some legal constraints. However, these are so weak that they actually permit a government to operate in the manner that it wishes. In other words, these legal zones offer the appearance of governance according to the rule of law, but they allow quite a lot of space for states to choose what they do within this legal space. At the same time, these areas of legal uncertainty can also be used to improve the law. And as such, it is the individual state's approach to legality which can result in the creation of legal gray zones. In other words, the key consideration is how a state chooses to engage with such gray zones and areas of legal uncertainty that makes the difference. And this is what both myself and Rebecca will try to illustrate, how various states over the course of the last 10, 20 years have approached such gray zones and what their approach to legality in general has been. So with that in mind, I'll have a quick look at the US war on terror and the Bush administration years in particular. What really distinguishes the two phases of the US war on terror between the Bush administration and then the Obama administration really matters. There's a distinction both in terms of approach to legality and legal gray zones, but also a distinction in terms of how these two phases of the war on terror were operationalized. If the Bush administration years were defined by the use of black site detention facilities, extraordinary renditions, outsourcing of ill treatment, and use of private operators to help individualize the war on terror, the Obama years have in many respects been defined by the exponential use of drones. Both of these phases and the manner in which they were operationalized has been quite influential, not just within the US, but also to their partners and other countries. So if we look at another distinction, in the Bush years, where the covert operations remained covert until the administration was forced to disclose them, in contrast, in the Obama years, we had a more voluntarily open approach, and this is something that Rebecca will discuss a little bit more. In constructing its war on terror immediately after 9/11, the US executive, and it is important to distinguish the executive response to the legislative response, and we can discuss that later, put forward extensive legal arguments in support of its interpretation of the general inapplicability of the human rights framework, the irrelevance of specific humanitarian law provisions to individuals captured and detained within the war on terror as a novel form of armed conflict, and the inapplicability of all the international relevant standards to the private actors engaged to facilitate various aspects of the war on terror. In short, the Bush administration approached what they perceived as legal gray zones within the international legal framework as a means to exploit the law and coat its operations with a veneer of legality. In other words, they used these legal gray zones to try to have the pretense of legality, and at the same time, the restrictions on it were so weak that it could do as much as it feasibly wanted. The Obama administration very quickly dismantled key components of the Bush administration's war on terror. It stopped using the word global in front of war on terror, and it started referring to overseas contingency operations within its national security and defense strategies. However, this reliance on extensive legal argumentation to justify extraterritorial counterterrorism and security operations which anticipate threats and punish alleged or expected threatening behavior rather than just respond to threatening activity as it's happening, has become a staple and has remained a staple in US defense and national security policies. And Rebecca will tell you more about it. And this has also been a very influential approach across several other countries. What distinguishes the Bush years in particular from these other countries, such as the UK, is the approach to legality. While the US sought to push international and domestic legal provisions to their very boundaries and limit and rescind the applicability of most legal standards to its war on terror, the UK have actually sought to utilize the law in their favor in many respects. During the Bush years, the US sought to show how and why the law doesn't apply to its overseas counterterrorism operations and extinguish any and all access to the relevant legal protections to individuals. In comparison, the UK, especially since 2000-2001, has persistently sought to construct as many preventative and anticipatory counterterrorism measures as feasible within the limitations of the law. In other words, they have tried to use anything that they have thought is an area of legal uncertainty as a means to give certainty that facilitates the state's counterterrorism operations and benefit from it. The reason why I've chosen the UK as one of the case study examples is because the UK was such a vital partner to the US from the beginning of the war on terror post 9/11, as well as the military operations in Iraq and Afghanistan. Rebecca will use some other domestic examples. And what the UK tried to do, in brief, close any perceived gaps in the existing legislation as it applied both domestically and, for some measures, extraterritorially. Think through what powers you need, not just right now, but also in the immediate and more distant future to counter terrorism and extremism. So while the US had a big focus on major operations outside of its territory, in the UK, especially after the Labour government year, has been very much a focus on legislation, legislation, legislation. So let me give you some examples. I will start just before the attacks on 9/11, the Terrorism Act 2000, which was used to consolidate existing and already extensive counterterrorism prevention legislation from the 1970s and 1980s. And this is particularly important because this legislation from the 70s and the 80s was both area specific and it was intended to be limited in time. It was legislation targeting Northern Ireland and not the entirety of the UK as jurisdiction. And as it was in the title of a number of the acts, it was meant to be temporary, it was meant to be emergency. As soon as the emergency was over, the legislation was supposed to cease. What the Terrorism Act 2000 did, however, is provide a permanent footing for most of the powers which were adopted for area-specific and very limited temporal time within Northern Ireland across the United Kingdom, and also extended a number of the powers. It added new powers. Why? Well, to address the special difficulties terrorism poses. The challenges were described as quite distinct from those caused by regular crime. The overarching aim was to ensure that all forms of domestic and international terrorism could be effectively addressed by the proposed provisions. One of the really big things that the Act did was to expand on the definition of terrorism, which has since become very influential to quite a number of countries, but also to start interlinking the use of immigration powers and immigration legislation as an aid to counterterrorism and counterterrorism powers, which is something that I will focus on in the time that I have left. Even though this was an incredibly comprehensive piece of legislation, by November 2001, this act was deemed to be inefficient and insufficient to allow the UK government to effectively engage in the war on terror. The Anti-Terrorism, Crime and Security Act 2001 was fast-tracked to Parliament and was in force within a month of being introduced in the House of Commons. And one of the major features of this legislation were the measures introduced following a notification of a 15-month derogation from Article 5 of the European Convention of Human Rights. This is important for two reasons. One, the UK was the only Council of Europe member state to seek a derogation under Article 15 of the ECHR following 9/11. In comparison, in 2004, Spain did not seek a similar derogation following the Madrid bombings. What the UK advised as part of its notification that it was in a public emergency linked to the presence of an unspecified number of foreign nationals who were suspected of being engaged in the commission, preparation, or instigation of acts of international terrorism. So additional arrest and detention measures were necessary. Without the derogation, these proposed additional and necessary measures would have been inconsistent with the UK's obligations under Article 5. So they actually sought not just a veneer of legality, but to be within the confines of the law through the derogation in some respects. The derogation in question was used to authorize indeterminate administrative detention of non-UK citizens who were suspected of terrorist activities but could not be deported or removed due to the principle of non-refoulement. Now, the fog of 9/11 could partially explain why it was only non-UK citizens who were targeted by the legislation. But if we look at the events in London of the 7th of July 2005, as well as subsequent terrorism attacks in the UK, these have been perpetrated almost exclusively, not entirely, by UK citizens, so UK passport holders. But this distinction between citizens and non-citizens, and who of these groups are more likely to pose a threat to national security, has since become entrenched. In other words, in broader terms, the legislation created two different sets of residents within the UK: those who comply with the law and are thus deserving of law's protection, and those who may be a threat to the first group at some unspecified time in the future, not just now, and as such are less deserving of core legal protections. Now, the part 4 of the legislation, which intertwined the targeting of suspected international terrorism, the certification of individuals as international terrorists, and the removal and detention with immigration and asylum law, has been struck down following a very important case in the UKA and others, on the basis that it's discriminatory and too onerous to a particular category of individuals. However, the link between counterterrorism and citizenship and immigration powers has very much remained embedded, albeit through different forms and different means within the legislation, and has continued on. It has been embedded through the Special Immigrations Appeals Commission in the UK, on the one end, and through this idea that there's some individuals who are less deserving of legal protections for acts that they may have committed or may be committing at some time in the future. In recent years, what has become, in comparative terms, a very much used and popular power has been the deprivation of citizenship. And we can also see how it could potentially be linked to the fact that from 2005 onwards within UK territory, so many of the terrorism activity has been committed by British citizens, British passport holders, some of whom are dual nationals, some not. Since 2005, over 160 individuals have been deprived of citizenship, dual nationals. The legislation is supposed to protect individuals from becoming stateless against international obligations. However, one of the more recent and widely discussed cases in respect of deprivation of citizenship suggests that it's not just dual nationals who may be targeted for deprivation of citizenship on the basis that it's conducive to the public good, but potentially individuals who may possibly have access to another citizenship through heritage. And this is the case of Shamima Begum, who was born in the UK, who has never set foot out of the UK in terms of being a citizen or a resident of another country, but whose parents have Bangladeshi citizenship. She does not have or has never held a Bangladeshi passport, and Bangladesh does not consider her to be a citizen. When she was 15, together with a couple of school friends, they decided to travel and traveled successfully to ISIS-held territory in the so-called Caliphate. And for several years, their fates were unknown. She was discovered by UK journalists last year in one of the camps, heavily pregnant with her third child, having lost 2 children already. And she begged for forgiveness and asked to be allowed to return back for the sake of her unborn son to the UK. Within days of the interviews that she gave initially, she was deprived of citizenship by the Home Secretary, who at the time was Sajid Javid. She has since appealed. So far, the appeals have been unsuccessful. At the same time, Bangladesh has refused to recognize her as a citizen. So she's in a situation where de facto, if not de jure, she is stateless. Regardless of what activity she may or may not have engaged in the so-called caliphate, the case in principle sets a very dangerous precedent as to what it means to be British, or in principle what it means to be a citizen, if citizenship rights can depend on heritage. And if we look at the example of the UK and how they have used the law, from indefinitely detaining those identified as international terrorists, it now banishes those of its citizens who have allegedly engaged in terrorism activities abroad by cancelling their citizenships. So in other words, the US war on terror, similar to the US one and the French one, as Rebecca will discuss, continues, even if the use of the language of war is actually, there is no use of the language of war. There's no use of any war language as such, but the categorization of individuals and the placement of individuals within pre-criminal spaces, having started in 2001 with those certified as potentially being international terrorists, continues on now to those citizens who are deemed unworthy of holding UK citizenship because they either may have committed or may commit criminal or potentially criminal behavior in the future. And I will stop here and I will pass on to Rebecca. If you have any questions, I'm very much looking forward to hearing them in the end.
Good evening, everyone. I was delighted to hear about this side of the story about politics of exclusions and the turn towards an intensification of the criminal law of the enemy, let's say. My side of the story is about how war becomes closer to peace. And when I say closer to peace, I talk about an extension or a dilution of the boundaries indeed between war and peace, and the idea that the war on terror follows the participants in these terrorist groups, the members of these terrorist groups, wherever they go. This is why we use the term anywhere war, and are potentially also indefinite in time, in the sense that the US, but also, as we will see, France and the UK seem to be inclined to follow and to continuously anticipate threats. I will share with you a caption of a video created by Forensic Architecture regarding a drone strike that was conducted by the US on the Durga in Data Khel in Pakistan. Durga is a traditional conflict resolution mechanism. And we see here how the objective of continuously anticipating threats by observing situations, by observing circumstantial evidence on the ground in distant territories, hoping to identify individuals that might belong to terrorist groups, is not only, of course, exacerbating error risks, but is also, of course, multiplying the occasions and spaces where intervention will take place. This is, of course, as part as the US war on terror that Rumiana already referred to. You know that since 9/11, the US has been involved in different territories in the war on terror in Afghanistan, Yemen, Pakistan, Somalia, Libya, Syria, and Iraq, and more recently in the sub-Saharan region. But the US is not alone in conducting this war extraterritorially. The UK has been involved in Afghanistan, in Iraq, and Syria. And of course, we can see different intensities in this extensive scope of war. The UK has been more moderate about how it frames its war on terror, probably pushed by a parliament that requires, that has to give authorization for involvement in foreign territories. But we have France also that started its military engagement in the Sahel region after Mali asked support to regain territory that had been seized by Islamist groups in 2013. And while France has really insisted in this intervention by invitation in order to justify its involvement there in the Sahel, that has been continuous since 2013, we see that this involvement is actually part of a broader strategy, a broader conflict that France pictures against jihadist groups. This also explains, of course, France's involvement against ISIS in Syria. France has been reluctant to formulate its legal interpretations as to how it engages with norms of IHL and how it justifies these interventions. But it's interesting to include it in our analysis to see how the US Obama administration's rationales have actually influenced its allies. These involvements and decisions to use force, extensive in time and space, potentially infinite, takes place in a context that is set to call for a military strategy that is driven by the objective to anticipate threats. And this is so because we are said that there is a new type of enemy that calls for a new form of hostilities. So here it's really the idea that a new type of enemy is calling for a new type of war. What are the characteristics of this enemy? It is said to be more dispersed. It is said to have these characteristics of having a transnational agenda, of having a multiplicity of fronts, a multiplicity of recruitment areas. And of course, it's crucial here to understand, and maybe we can talk a little bit more about this, that the description of these terrorist groups fought in the war on terror is also constructed by how they are perceived. So in other words, their identity is a mixture of what they are, what they say they are, of course, in propaganda documents, and what states describe them to be as well. So to a certain extent, when France used the umbrella term, the war against jihadist groups, to talk about its extraterritorial interventions, when the US refers to Al-Qaeda and associated forces, and here notice that I don't mention the UK that distinguishes between the different groups against which it's involved, we have the feeling for the US and France that these groups are interchangeable entities, that they are the same enemy as part of a unique conflict. And of course, this exacerbates the feeling that we have a transnational threat. Macron himself referred to the Hydra-headed enemy. So this leads states to engage continuously and to have a continuous anticipation of threats. And in that context, because this is a story also about, as Rumiana really sharply explained, this is a story about what functions the law can perform and does perform in this conundrum. And in this context, what we see is that a series of propositions about how the laws on the use of force should be interpreted have been articulated, in particular, very robust one by the Obama administration to justify the use of force against members of terrorist networks for the threat that they pose as individuals, even when and wherever they are, even when they are not seen as currently preparing an armed attack, to use a jus ad bellum vocabulary, or not currently participating in hostilities, to use the jus in bello vocabulary. So what is at the heart, you understand, of these legal rationales is that we anticipate threats. So we don't wait for these acts of war, to say it this way, to say it simply, to be perpetrated in order to take action, in order to conduct a drone strike, for example. These rationales were composed mainly, so I will not go into details, but it can be a good basis for our discussion. These rationales include, of course, an extensive version of the right of self-defense, one that argues to depart from the interpretation, the traditional one, still, of course, the one that stands. I will say a few words about this and give a caveat about the fact that this is not, of course, the law as it is. It's the legal interpretations that states argue for. So the idea of self-defense that is not responding to an imminent armed attack, or an armed attack that is currently being perpetrated in front of our eyes, so that has already taken shape in reality, but rather the idea that there would be a right of self-defense against individuals who pose a continuous imminent threat. So this is one aspect that has been argued for. And then, of course, we have seen legal rationales related to or based on international humanitarian law, the jus in bello, about the temporal and geographical scope of war. And here I would refer back to what Rumi told you before. It's about exploiting uncertainties about the end of armed conflict. That is a gray area in contemporary IHL, and exploiting gray areas about the geographical scope, in particular of non-international armed conflicts. And we can, of course, discuss more about this in the Q&A. But what is important to see is that these legal interpretations of the norms that were articulated by the Obama administration, that still many states might express objections about, many scholars as well. Again, it does not concern, here we're not talking about the legislata, the law as it stands, but rather we try and understand how the law and its uncertainties and gray zones have been exploited in order to normalize an extensive warfare in time and space. And including France here and the UK is interesting to include them in the scope of our study, to take heed of the reach and breadth of the sophisticated legal rationales crafted by the Obama administration. And overall, what I find in my work is that the influence of these US rationales is more important than anyone would admit. France has somehow benefited from remaining silent. No harsh criticism has been formulated on its war on terror. It has benefited from silence and from the idea that intervention is justified by the invitation given, formulated by the states in the Sahel. But we see in official documents and parliamentary debates as well, that France intends to conduct a war against jihadist groups wherever these groups emerge, and perceives its intervention in Mali as having to persist for as long as this terrorist threat will exist. The UK, for its part, as I mentioned before, embraces a transformation of the right of self-defense along the lines that I mentioned before, even if it's more cautious on the use in bello side, for also the reason I mentioned before, the parliamentary authorization necessity. We have seen this when it moved from Iraq to Syria, and that it had again to ask for authorization from the parliament, even though we saw that the UK conducted a drone strike against Riyadh Khan before it got this authorization. So this tells us that there is the idea that conflict follows its participants as well in the UK. We can talk a bit more extensively about France and the French operational and legal logic. I do believe that the military strategy that it has thoroughly crafted implies extensive legal interpretations. This has, of course, to be confirmed or denied by French legal officials, but I think it's important to include it in the debate in order to foster and force conversation on these aspects and to understand what it is doing in the Sahel. Now, to tell you a few conclusive words about what I think is at stake here. And how the law is used, because it's quite cynical, of course, if we end the discussion here, and it wouldn't be a problem, of course, to end with a cynical note. There will certainly be some of it lasting even after my conclusive remark. I do not think that it tells us that IHL and the use ad bellum are overall in our contemporary world pushed to breaking points and lose their constraining function. I think that there is something very specific in the situation that we are observing here with Rumiana, and that there is something very specific in the relationship that opposes states and jihadist groups. One that could be characterized as essential enmity or infinite enmity, and that might explain the conduct of radical extensive warfare, but also that some states feel so comfortable exploiting legal uncertainties, even if it means making them lose their constraining function. Thank you very much for your attention, and I'm looking forward to discussing with you.
Thank you, Rebecca, for that very illuminating presentation. And thank you so much, Rumi, to you as well for your wonderful presentation. Apologies for introducing you as my doctor, almost introducing you as my doctor. Of course, my doctor is not here tonight. We're going to jump into questions, but I think that the way Rebecca has wrapped up her presentation, and in a way both, is quite interesting, because it can kick us off for what's coming. Rebecca alluded to also Rumiana's the end of Rumiana's presentation, whereby there is a sort of hierarchy of citizenship being created in some of these countries which are combating terrorism, and an extension in time of the measures that creates a presumption of discrimination against them in terms, and that might enable discriminatory practices against certain individuals. And we have a question. Our first question goes a little bit in this direction. We have Haure Ahmed. Apologies if I'm not pronouncing the name correctly. He or she thanks our panelists and has a question regarding the prosecution of terrorist members. And specifically, they want to know whether there is a UK provision to prosecute, for example, ISIS members just because they're a member of the organization and are not committing any crimes. So this is probably a question for Rumiana to kick off. And then there's a second part to the question, which is from a legal perspective, have any of these crimes for terrorism constituted a war crime that amount to cases being brought to the ICC, or could there be a case envisaged in this regard in the ICC? So Rumiana, and if Rebecca wishes to take up some of these aspects of this question, of course, you have the floor.
Yeah, thank you very much for your question. Indeed, from Terrorism Act 2000 onwards, there's very extensive powers in terms of prescription of an organization. In other words, defining an organization as one that engages in, for example, terrorism activity or national security threatening activity, the members of whom are in fact committing or about to commit a crime if they're a member of the prescribed organization. There's also offenses in terms of, being a member of a prescribed organization which carry a sentence with them. And indeed, some of the individuals who have managed to return to the UK if they have been successfully prosecuted, they have been prosecuted predominantly for the prescription offenses, in other words, that they were a member of such an organization. The issue has been that these are not necessarily offenses that carry a particularly long sentence. There's also some specificities in terms of the domestic UK legislation in terms of how long you can serve a certain sentence, something that the current Tory government has been seeking to change. So say, for example, you're not expected to be paroled after halfway through mark, but you have to serve at least 2/3 of your sentence. Same thing happened a couple of years ago in respect of incitement and encouragement of terrorism offenses. But in reality, the UK government ideally would want to prosecute individuals for offenses that carry a larger sentence, so offenses that carry a sentence of 10 or 15 years, so going beyond just membership and into actually having engaged in preparation, support, facilitation, commission of terrorism activity. The problem, and I think it's the same problem in the context of an international-led case, is evidence. And finding sufficient evidence that goes beyond just being a member of a terrorist organization, evidence which is in the battlefield, in a different jurisdiction, which requires the presence, expertise, and investigation of trained individuals. And naturally, them being allowed to be in that other jurisdiction depends on participation of the state and being allowed or invited by the state to carry out that investigation. And I think this is one of the major problems, the collection of battlefield evidence, which I think would hinder prosecution and hinders prosecution both domestically and internationally. So there's a lot of reliance instead on information exchange through intelligence services. But unfortunately, not all of that information is allowed in standard criminal court proceedings. So that is another complication. In terms of ICC and war crimes, again, terrorism in general is not, there is no definition of terrorism within international law as such, or no uniform definition. So if you look at any UN Security Council resolutions or any UN documents or reports by special rapporteurs, this is one area of concern that has been persistently brought up, especially since 2001. And this lack of a unified and uniform definition of terrorism is also one of the issues as to why it would be very difficult, in my view, to try to bring a war crime prosecution as such.
Thank you. Thank you very much, Rumiana. Rebecca, do you think that the development of a definition on terrorism would improve things and bring clarity to the very different approaches that you described very well regarding the counterterrorism measures taken by American and the UK governments and also the French government?
So that's a good question, but I think that as I explained in my presentation, I don't think the involvement, the actual involvement, will depend on the definition of terrorism. I think here we're talking about specific, what would help in order to delineate conflicts is to distinguish between different jihadist groups or different terrorist groups. This would be a way to constrain conflicts in time and space. Yeah.
Thank you. No, certainly. I mean, I think, so to what extent do both strategies here, both the US, UK strategy and the rest of the world, incorporate these distinctions, differentiate between different entities? Because of course we have a global framework of sorts, which is of course dominated by the countries of the P5. And this goes to a question by Berenice, that was posed by Berenice. The P5 have plenty of leeway in terms of how they can define their strategy. And that is one way of confronting these threats. And to what extent does this global strategy of the P5 address differentiated entities or differentiate between different contexts and situations? And how does that affect the outcomes?
Thank you. That's a really good question. In my view, since UN Security Council Resolution 1373, which some have considered to be lawmaking UN Security Council resolution, since it drove so much of the domestic legislation in terms of counterterrorism in the context of linking immigration and counterterrorism and financing and preventing the financing of terrorism organizations and others. I think that's a point that we can see that there was a global strategy because there was clear agreement by the Permanent Five in terms of how significant a threat terrorism poses, how comprehensive the measures to combat it have to be, and that to combat it successfully, it's not about one or two particular domestic approaches to respond to one or two domestic events, but rather it's a transnational, transborder threat that needs to be combated by all together. And I think at that particular point of time, possibly throughout the first phase of the US war on terror under the Bush administration years, when the US was still very much a leader in that sense, I think there was a strategy in place. But in my view, it was very much a case of, yeah, in the US particularly, there was a distinction between Al-Qaeda and everybody else, somewhat similar of the UK, but there was also this big, large, just terrorism threat in general, which I feel is very useful to states in many respects, because if you have the big threat of terrorism constantly in view, well, as terrorist organizations evolve and change, and they do, and as their methods also evolve and change as states legislate more and more and adopt a range of measures, I think it's easier to continue evolving your responses and to continue evolving your legislation if you might have a particular distinguished and distinct enemy that you are constantly targeting politically, but legislatively you keep it to terrorism in general. So if I to come back to the first question in the prescription legislation, the list of prescribed organizations in the UK is very, very extensive. It ranges from right-wing groups to very much groups that you associate with terrorism, from the IRA to Al-Qaeda, ISIS, etc. So there is distinction within the legislation, but the terminology is very general. That's, I think, in terms of states thinking, that's done very, very pragmatically and intentionally.
Thank you. Thank you. Shall we move on to the next couple of questions? We have two very interesting ones. The first one is posed by someone who signed on as Jus Kogans. How does IHL recognize possible claims, IHL of course being international humanitarian law, recognize possible claims of a transnational, non-international armed conflict against a decentralized terrorist group? And I will follow up with another sort of related question within the same field by Christopher O'Meara, which is, to what extent does jus ad bellum necessity feed into or help address your concerns about a, quote, overly expansive interpretation of the lex lata? So should we start now with Rebecca and then move on to Rumiana?
Thank you, Leon, and thank you both for your questions, which I think are really crucial ones. So the first question on IHL refers to the fact that there's, as you know, no unitary concept of armed conflict. So the Geneva Conventions recognize two types of armed conflict that are distinguished according to the status of the parties. So an interstate conflict qualifies as an international armed conflict. And a conflict between a state and a non-state actor qualifies as a NIAC, a non-international armed conflict. So your question is absolutely valid, and I think that this is what has helped, of course, to consider a NIAC as a NIAC, the transnational armed conflict against terrorist groups, is that even though traditionally the distinction between the two types of armed conflict informally or historically corresponded to a territorial characteristic. Yeah. So on the one hand, interstate conflicts were considered as involving border crossing, whereas on the other hand, in traditional civil wars, a conflict between a state and a non-state actor would remain within the state's borders. So this has been, this historical fact has been exploited also by lawyers to push against this idea that a situation where we would have a state and multiple non-state actors or one non-state armed group could not qualify as an IAC. But personally, if you ask me, and of course this is a debated issue, IHL was not made to constrain armed conflict, but to regulate them. Therefore, because it's a definition based on the status of the parties, wherever they move, it's actually a reasonable interpretation of the law to say that a NIAC can be a conflict opposing a state and a transnational non-state armed group. Concerning now the question on jus ad bellum and necessity, what we see, and this is a very interesting phenomenon, is that when we depart from the idea of a right of self-defense against an armed attack that is either currently perpetrated or forthcoming, imminent, in order to use self-defense against individuals who belong to a group that carries continuous hostile intent. When we see this movement, what we see is indeed, as you have a good intuition, the principle of proportionality and the principle of necessity cannot refer to material circumstances. The test, the proportionality and the necessity test cannot, by definition, be conducted because there is no armed attack, no material circumstances according to which it can be tested. However, what we see in this chain of reasoning proposed by states in order to extend the right of self-defense is a metamorphosis of this principle of necessity. And the test becomes not, is this use of force proportionate and necessary in order to halt and repel this armed attack? Rather than this, the test becomes, is this use of force proportionate and necessary to the threat, to counter the threat posed by these individuals and these terrorist networks? And here we see a metamorphosis that fits into this rationale. Of course, we can formulate very strong arguments against this, in particular also based on normative arguments. I hope I answered your question.
Thank you very much, Rebecca. Rumiana, any final thoughts on these questions?
Yeah, the only thing I would add was the first question, and as Rebecca very well explained, one of the issues with IHL is that it regulates armed conflict, but the two categories of armed conflict were very much definitions, were very much written and interpreted at a time when the thought was on borders and very traditional type of conflicts as we understand them. So in the context of the US, and not just the US, post 9/11, this is precisely where they looked at and thought this is an area of legal uncertainty because it looks so much into the past. There's nothing that regulates the now, which is transborder with an irregular and asymmetric actor. So they spend very extensive time and used a lot of legal argumentation to both argue that the conflict with Al-Qaeda was a non-international armed conflict, but at the same time was such a novel and particular and specific type that almost none of the specific provisions and protections regulating combat within IHL, regulating categories of individuals, for example, apply, because it's a new and novel and specific conflict that IHL has not defined entirely yet. So it has elements of one end, elements of the other end, but it's novel in its own right. And this is where we can see how legal uncertainty can become an area of very weak legal constraints for a state. And I think it's perhaps an area, if there is international willingness, that does need to be regulated better, because it's still open for exploitation.
Thank you, Rumiana. Maybe we have time for a couple of more questions. E.J. Veldman asks panelists, what is the role of China? We have a new actor in international geopolitics that is playing a big role in many areas. And is there a role to be played by China here? Is the legal framework, which is favored by the P5, US, UK, and France specifically, is that legal framework going to be challenged, or is it being challenged? And what are the implications of that? Would anybody like to pick up on this question?
Thank you. Very, very interesting question indeed. I think if we're to see in terms of influence of China, we can definitely distinguish between how the UN Security Council has worked up until, say, the Bush administration years 2010, 2012, and what I think has been a big shift, especially since the conflict in Syria has started. Now, Rebecca has noted that the UK has very much been restrained as to how much they're able to do extraterritorially by Parliament. There's been some very famous debates within Parliament whether to engage or not to engage with airstrikes in Syria. There has also been public unwillingness to engage in activity following Iraq and Afghanistan. But at the same time, you can see that there's a lot less agreement in many respects within the documents, I feel, that come out of the UN Security Council. There's a lot less drive, there's a lot less influence by the US. And I say that because one of the big things that happened immediately after 9/11 was that the US was so able to influence policy, direction, how and what was written and included in international documents, not just within the UN Security Council, but also in NATO. We shouldn't forget that for the first time in NATO's history, immediately after 2001, they triggered the article in respect of collective and individual self-defense. First time in history. That's big. It hasn't been triggered since and has never been triggered before. If we compare it to now, I think the fact that the US is very much in the current administration pulling back from being a leader in terms of international security, in terms of combating terrorism transnationally, I think this is where China's influence, who I think is being quieter and more behind the scenes, will become a little bit more prominent. In general terms, the fact that they're not really signatories to many international legal documents, their general attitude towards human rights, for example, and international human rights documents, to me, suggests that if they do decide to engage in any such activity, they wouldn't even attempt as much as the US and the UK have done to quote the activity in a lot of legal argumentation in terms of this is why this action is necessary, it's proportionate, it's legal, it's not impacting on rights. But I think it's still what the influence will be. It's more for the future, especially seeing the current situation.
Thank you, Rumiana. Any final thoughts on this question, Rebecca, before we close the Q&A and conclude our first ASER webinar?
Very quickly, I think Rumiana very sharply mentioned very important thoughts on the influence on the international scene. I think it's interesting, just one word before we close. I don't want to spend too much time on this, but it's also interesting to see what China is doing domestically based on rationale of counterterrorism, and actually delving into politics of exclusions against million ethnic minorities, most of them Muslims. So I think it's interesting to have a look at that for those of our attendees who are interested.
Thank you very much, Rebecca. This goes back also to the hierarchy of citizenship and minority discrimination that is also happening in the West. Thank you very much to both of you for very insightful presentations and a wonderful session with our participants. Thank you to the participants for joining. We still had a few questions. My apologies to Taylor Woodcock, Kate, Christoph, and others that were out there. Let me take this opportunity now to invite our attendees to join for our ASER Terrorism, Counterterrorism, and the Rule of Law Advanced Summer Program. It's the 10th time that we are organizing this. Both Rumiana and Rebecca will be participating as speakers 24 to 28 August 2020. aser.nl, register now, applications are open. You will receive a short poll now. I would like to thank the Communications and Events Department of the ASER Institute. And for now, I wish you a good evening and a great rest of your week. Thank you very much.